I want to get into sort of the broader legal arguments that are out there, but first let's talk about some of these specific issues that you've mentioned here. Assault weapons bans. Do you see any of them surviving post-Bruen scrutiny?
No. Now, this is very important for people to understand about any kind of arms possession ban. When you're dealing with a ban on an arms, now that could be a law that bans the possession of AR-15s, which, as you know, are nothing other than semi-automatic firearms. If you're dealing with a ban on so-called large capacity magazines or a ban on ammunition, these are forms of arms under the right of the people to keep and bear arms shall not be infringed. The reason why this is important is because the United States Supreme Court in the Heller decision in 2008 already did the analysis of looking at the text of the Second Amendment and then looking for historical analogs of any longstanding traditions of restricting or banning firearms of any sort, and concluded that if an arm in modern day America is in common use, it cannot be banned, it cannot be thwarted, it cannot be banned. Period, full stop. Now, all of these so-called assault weapon bans deal with semi-automatic rifles and or magazines that hold more than 10 rounds. These are clearly arms, and they cannot be banned because it's understood by the world that these are in common use for lawful purposes. Now, the anti-gunners are trying to redefine that standard to say the legal standard is not that an arm has to be in common use for lawful purposes. They're trying to redefine and say, no, that the pro-Second Amendment people have to show that these arms are in common use for purposes of self-defense. But that is absolutely 100% not true, because if you just look at the dissent of Justice Stevens in the Heller case, he and his fellow dissenters, including Ruth Bader Ginsburg, talk about how now they disagreed with this test, but they pointed out that the in common use test by the Supreme Court was discussing in common use for all lawful purposes, including hunting, self-defense, recreational use, and so on and so on. So, and then you look at the Caetano case from 2016, where the Supreme Court says that you and I and our listeners have a right to modern firearms. That this argument that we're only entitled to muskets is silly. No, it's like, again, the argument that the Supreme Court points out, which we've all pointed out before, it'd be like saying you have a First Amendment right to pamphlets, but not a First Amendment right to use the TV or the telephone or the internet. That's clearly not how the Constitution works. So again, keep in mind that
I think they called it borderline frivolous.
It did, borderline frivolous. So the bottom line is, when you're dealing with a gun ban case or an arm ban case, as long as it's in common use. Now the question is, what does in common use for lawful purposes mean? Well, the best indication is from the Caetano case, which talks about stun guns, which were invented in the 1970s, being in common use. And Justice Alito, in his concurrence, talks about approximately 200,000 stun guns being owned by Americans for lawful purposes. He doesn't discuss about stun guns being used for self-defense or the number of times they're used for self-defense or anything like that. He just points out that possessing stun guns for Americans, 200,000 or more, that's in common use. And I think that's very important to understand, because the Bruen methodology, which is the text first and then history second, has already been done when it comes to these ban cases, like so-called assault weapon ban cases. So it should be very easy for our side to win these cases as they move forward in the system.
Okay, and so we'll go from because I figured that's where you were going to come down on, and maybe we'll go from easier to harder here.
Sure.
How about the sensitive places laws that you see in New York and New Jersey that have they've already been ruled unconstitutional by lower court judges to this point, but do you see any of those restrictions upstanding? For instance, the private property, sort of flipping that consideration on its head. Most states throughout American history have considered it legal to carry on someone's private property unless they post a sign that says you can't. Now, these states want to do the opposite of that, where make it illegal to carry on private property unless the owner posts a sign that says you can. Do you see that standing up?
I think almost all the places that the government has defined as sensitive places, which, as you know, is a euphemism for government mandated gun-free zones, are going to fall by the wayside. And let me tell you why.
All of them. Included. What about the ones that the court
but almost all of them. Almost all of them. There are, in fact, and the Supreme Court already said this, there are places that can be government mandated gun-free zones if government wants to do that. For example, if you read the Nysurpa versus Heller case, they make 3 examples. They say that a sensitive place can be a polling place, a sensitive place can be a legislative chamber like Congress, and a sensitive place can be a courthouse. Now, if you go back in time and you take a look at this, you'll see that these sensitive places, they all touch on government. They all had, certain aspects of protections and whatnot. They weren't just, stores, taverns. They weren't farmhouses, any of these sorts of things. So let's just take New York. So New York says if a place serves alcohol with a license for alcohol, that's a sensitive place and they can ban guns there. That's clearly not true because remember, the first thing to understand, Stephen, about the sensitive place analysis is what Bruen's methodology is. So the first thing is Bruen says you look at the text of the Second Amendment as interpreted by the Supreme Court. And once that text implicates a right to keep and bear arms, then the burden shifts to the government to come forth with historical analogs. So the first question is when you're dealing with historical analogs, Stephen, is where in time do those historical analogs come from? And the answer is they come from the 18th century in the time period of the adoption of the Bill of Rights in 1791, because it's black letter Supreme Court precedential law that says that when you're interpreting the Bill of Rights that was adopted in 1791, you look to the intent and the understanding of the people that adopted it at the time they did it, which is the late 18th century. So you get past 1826, which is the year that Thomas Jefferson and John Adams both passed away on July 4th, 1826, on the 50th anniversary of the signing of the Declaration of Independence. We're certainly indicating there's some divine intervention there, right? You get past that, the founding generation is by and large, with very few exceptions, has passed away. So anything after that is not going to teach us as lawyers or judges what does the Second Amendment mean? Because it's too late in time. The founding generation is gone, right? We're dealing with other generations and their intent doesn't matter so much. So you go back to 1791, Stephen, and you try to figure out what are the sensitive places. And again, you have those 3 examples: polling places, courthouses, and legislative chambers. And beyond that, you really don't have any. We know that you could have alcohol in places, for example, Francis Tavern in New York City. The Patriots met there over beer and they talked and they all had guns. We know, of course, that in Boston, they would meet at Sam, Adams' place. And there's countless examples. There's a famous story of Thomas Jefferson leaving his pistols behind in a tavern on his way to Congress, a famous letter that he wrote. So, that's an example. When you go back in time and you look at historical legal analogs of bans of guns in sensitive places, they're very, very few. Now, you do bring up this notion of the default rule. The default rule in American history is you are allowed to bring guns onto private property unless you are stopped. The only kind of, and the best example of that is think about hunting regulations where in America, generally speaking, you're allowed to hunt on other people's lands unless they do a proper posting that says no hunting. Again, right. The presumption is that you're allowed to bring guns onto other people's land unless they tell you not to do so.
Yeah. And so, that does seem like an extremely novel approach that they're taking in New York and New Jersey and probably California here soon. But I think that alone, doesn't that call it into question just because it's never actually been tried anywhere before?
Yes, exactly right. Because the Supreme Court has said that, this is what it said in Bruen: if there is a social problem at the time of our founding that the founders looked at, had to consider and deal with, and if they did not deal with it in the form of some form of gun control, that basically tells that the Second Amendment does not permit it. So I'll give you an example. So the anti-gunners in America are trying to say that wherever a lot of people congregate, that is a basis for us to say you can't have guns there. But now let's go back. So let's go back as historians, applying the text first and then historical analogs second, which is what Bruen tells us to do. You go back to the founding fathers and you ask yourself, at the time of the founding, when people congregated together, Did they ban guns if there's a fear for safety? And the answer is absolutely not. They went just the opposite direction. The best example of this is churches, where every Sunday, everyone in the community, including, Indian tribes and criminals and others that might want to do harm to the colonists or the patriots, they would come together at a church on a Sunday morning. Everyone knew this. And what did the founding fathers do when people congregated together? They did not put up no guns allowed, right? No guns allowed here signs. Instead, they encouraged people to bring guns to church. So that's a kind of historical example the Supreme Court said is very telling, that when you interpret the Second Amendment in modern America, what did the founders think about it? And when you had people congregating together, the answer was not gun control. It was just the reverse. It was let people bring guns. In fact, actually encourage people to bring guns to defend the community. And that would be an example of talk about, Times Square and all these other things, which of course, putting up a sign that says no guns allowed is absurd. The founding fathers were very familiar with the Italian Enlightenment philosopher Cesare Beccaria, who wrote extensively in a book called On Crimes and Punishment that the founding fathers used extensively to write our Bill of Rights, including the criminal procedures, the Eighth Amendment, cruel and preventions on cruel and unusual punishments. But in that book specifically, he talks about the right to keep and bear arms. And Cesare Beccaria literally writes that any laws that forbid the carrying or use of firearms by private citizens does absolutely nothing except help the criminal and hurt the law-abiding. That is not an NRA slogan, Stephen. That literally comes from the 18th century, Cesare Beccaria, whose book was so influential to the founding fathers that it was basically assigned reading at the Constitutional Convention.